Now we'll see this concept of a small company. This is yet another novelty. This is not like a separate kind of a company. It is basically a classification in the act which has been brought. Now in the new act, the classification is no more based on a public company or a private company. In the 1956 Act, we could see a clear distinction where all the sections were applicable to a public company and exemptions were given for a private company. But in the Companies Act 2013, the distinction is based on the company being a small company or a large company. If the company is able to qualify to be a small company, then it will get certain privileges. Otherwise, be it private, public, listed, unlisted, every company will be looked under the same scanner only. So what is a small company? As I was mentioning you, a small company is a company other than a public company. So a public company can never qualify to be a small company. It's only private companies which can get this privilege of being a small company, provided either their paid up capital. Here, not both the limits have to be satisfied. It is enough if any one condition is getting satisfied. That is, either the paid up capital can be less than 50 lakhs or the turnover can be less than 2 crores. So either of these two conditions, if the company is able to satisfy year on year, then it can continue to enjoy the benefits which are available to a small company. And even the limits, a provision has been made where the government might enhance it in the future. So for a capital, it says from 50 lakhs to 5 crores, or turnover from 2 crores to 20 crores. But as of now, it's 50 lakhs and 2 crores. And there is a or in between both of them. So any one condition is satisfied, that is sufficient. Now, again, this small company privilege is also not available to a holding company or a subsidiary company or a company registered under Section 8. That is, in 1956 Act, what we call as the Section 25 companies. So those companies also cannot get this exemption of a small company, and also companies which are registered under any special act. So other than that, if the private company is able to satisfy the threshold requirements, it can enjoy the benefits available to a small company. The benefits which are available, they are more or less the same which are available to a OPC. To OPC, some more extra benefits are available, being a single member company. To a small company, a lesser number of privileges are available. Same annual return, the same requirement is there. If the company secretary is there in the company secretary has to sign the annual return. If not, again a single director can sign it. This point is worth to note here. In a OPC, there is a provision where the company can have a single director, so the single director is signing. A small company, it has two directors. A private company will have two directors, but still the Act gives the privilege where a single director can go ahead and sign the annual return. No outside certification from a PCS is mandated. Board meetings also, same provision is there. 2 board meetings in a year, each half of the calendar year, with a minimum time gap of 90 days between the 2 board meetings. Financial statements, again, the requirement of cash flow statement is not there, and the mandatory rotation of term of auditor is also not applicable. I think this is one area where really the auditors can be happy about, because if the company is a small company, the mandatory rotation is not going to be there. It's only if the company having capital more than 50 lakhs and having turnover also more than 2 crores only, that auditor rotation will creep in, or if it's a public company. Otherwise, still they can keep continuing. I think most of the private companies will fall under this limits, or they can ensure that they are falling. Probably turnover is not something they can control, but capital is something they can always control. So this is one saving grace for the auditors. Dormant company. This concept of dormant company also, as it is currently also, it is there by means of a circular. Some 2 years back, the Ministry of Corporate Affairs, they had come out with a circular, and they had marked a number of companies as dormant companies which were not filing their financial statements or annual return for the last 3-4 years. So those companies were marked as dormant companies, and all their filings were stopped. They were not permitted to do any further filings till they applied to the ROC and activated themselves, and then only they could file any of their returns. Now, in the Companies Act of 2013 itself, this concept has been incorporated, but in a slightly different manner. So it not only recognizes the inactive companies, it also recognizes the fact that many a times companies are formed not to do a business immediately, but probably to hold some asset or some intellectual property right, or to do business, because there's always a gestation period. So recognizing the need for that, the Companies Act of 2013 has introduced this concept of dormant companies, where if a company is formed for any of these purposes, or if it remains inactive for some period of time, then the company itself can apply to the registrar and get itself marked as dormant. It will enjoy certain privileges based on that, and the ROC will not take any steps to strike off the name of such a company from the register of companies maintained by it. Again, as I was mentioning you, special requirements, privileges are available to a dormant company. These kind of companies will be required to pay annual fees to the ROC to maintain their status of dormant companies, and many of the requirements of filing returns and forms will not be applicable to these companies. Their financial statements are not required to be have a cash flow statement as its part. Again, meeting also, since it's more or less an inactive company, 2 meetings are sufficient in a year. And whenever the management feels that now there is an opportunity to do business, or they want to activate the company, they can make an application to the registrar and activate the company. The registrar will be maintaining separately a register of the dormant companies. In the MCA, the master data, we can see the company marked as dormant company. So this is basically a right given to the company, where the company itself is able to identify that at present I'm not doing any business, but I would still like to have my company alive in the MCA registry. Independent directors. I think Mr. Mohan Ramakrishnan has given us a beautiful introduction about the independent directors. This concept of independent directors, I personally feel that it has been completely blown out of proportion. I can see a number of conferences and international conferences happening only on this concept of independent directors. Madam Bhavani was telling us that the whole weight is on the auditors to ensure that the everything is going right in the economy. But when this concept of independent director is there, it gives us a feeling as if the whole economy can feel that as long as a company has an independent director on the board, everything is going to go well with that company. The kind of qualifications and disqualifications which has been prescribed for appointment of independent directors, the duties which has been cast upon them, and the provisions which have been made to ensure their independence, it is really humongous. But I personally believe that independence is always a state of mind. It has to come from within. Any number of provisions, any written law cannot bring independence unless it comes from within. Nevertheless, law is law, it has to be complied with. I am not going through the qualifications and disqualifications in detail. It is purely academic in nature. It is a whole list is there, relatives and consultants and their relatives. A very, very, very exhaustive list, a very challenging thing for the companies to see how they are able to find out a person who is not falling in any of these categories, so that the person can be appointed as an independent director. Interestingly, no minimum qualification has been prescribed for an independent director. Having laid out a long list of disqualifications, it is more or less qualitative in nature, but there is no educational qualifications prescribed which is required for a person to get appointed as an independent director. And even to make a point here, the Companies Act 2013 has gone much ahead of the listing agreement. The listing agreement itself was pretty stringent in its requirements of an independent director, but the Act has gone far ahead it, and it has imposed many new restrictions on independent directors. As regards the mandatory appointment of independent directors is concerned, listed companies still it is applicable. Currently also, as per listing agreement, they are required to have independent director on the board. That same requirement still continues under the new Act also. Apart from that, other unlisted public companies which have a share capital in excess of 100 crores, loans and borrowings in excess of 200 crores, or a turnover in excess of 300 crores, they will also be required to have an independent director. Some of the important points to note here is that under the listing agreement, as regards as the fraction was concerned, the fraction could be rounded off to the nearest one. So if the company has 4 directors, if 1/3 requirement of an independent director is there, it could have a single director. But now it is specified that the fraction has to be rounded off to the next one. So effectively, if there is 4 directors on the board, then at least 2 will be required to be independent, even if with that 1/3 criteria. Also, it has been stated that because of this threshold limits which are given for an unlisted public company, If in a subsequent year after the appointment of the independent director, if the company falls out of this threshold limit, it would still have to continue with the appointment of independent director for the tenure of the appointment. So in the next year, if it is not falling on the threshold limits also, it cannot say that I don't fall within the threshold limits, I don't require an independent director, so I am sending him out. The independent director will have to be continued till his tenure of appointment. And if any other law prescribes a higher number of independent directors, that will take precedence over the Companies Act. So the Companies Act prescription is the minimum threshold limit, and if any other law needs a larger number of independent directors, that will have to be looked into. A transitional period of 1 year has been provided to the companies to comply with this requirement. Again, here interestingly, a tenure of appointment has been prescribed, just like auditors. A maximum tenure of 2 years or 5 years each has been provided, with a cooling off period of 3 years. This again is a new introduction in Indian context. In the UK's combined code, we can see a 3 tenure period of 3 years each, which was erstwhile in the Companies Act. It was not, I mean, in the company's Indian company law scenario, it was not there by means of listing agreement, but now this maximum tenure has been introduced. The only saving grace here is that, unlike auditors where the existing tenure will be counted, for an independent director the existing tenure will not be counted. So any independent director on your board, after the Companies Act 2013 is notified, the 5-year period or the 10-year period of tenure will count after the act is notified only, and the existing tenure will not be counted. And regarding the data bank of independent directors, since it's so much prescriptions have been made regarding the qualifications, disqualifications, the government has come out with a provision that it will maintain a data bank of persons who are qualified to be appointed as independent directors, and the companies can choose and pick up from that database. However, the end responsibility will lie with the company only, and the government is not going to take any responsibility whether the individual is actually qualified to be appointed or not. So the company will have to carry out its own due diligence to see that the person whom they are appointing is fit enough and is abiding by the provisions of law. As Mr. Mohan Ramakrishnan was mentioning, I think India is one of the first countries which has mandated for certain companies to have one woman director on its board. If we see the threshold limits, these are more or less same as that of companies which are required to have independent directors. So in my personal opinion, the companies may look into a scenario where they would try to appoint a woman as an independent director, so that they are able to satisfy both the requirements of a women director as well as an independent director. So I think this is one area where the women can really feel happy about the government. Though I personally don't recommend a quota system, but still something good is given to us, let us appreciate it. So apart from the requirement that a women director needs to be on the board, no other qualifications or any other minimum requirements are prescribed. As long as she is a female, she is capable of being appointed as a women director on board of the company. Resident director, this is again a new requirement in the Companies Act of 1956. We do not have any requirement where any director needs to be in India. Only for the purpose of AGM, we had to ensure the shareholders are in India at the time of the AGM happening. But as far as directors, there was no provision. But now the Act has mandated that at least in every company, there is no exemption for any OPC, for any small company, listed, unlisted, public, private. Every company should have at least one director who has stayed in India for at least 182 days in the previous calendar year. So now every company will have to ensure this requirement.